As you heard there from Merrick Garland, those two words clearly unconstitutional, talking about that Texas law. And it's unconstitutional, in his words, in two ways, because it violates the 14th Amendment and because it violates the Supremacy Clause. Now, the 14th Amendment is the amendment that gives all American citizens equal rights under the law, including the right to privacy. And that is the amendment that Roe versus Wade, the landmark Supreme Court case that gave the right to abortions to American women, that's the amendment that it is based on. The Supremacy Clause basically states that any state law cannot supersede or go against something in the Constitution, that the Constitution is above state law. So for Merrick Garland, this Texas law goes against those two main constitutional principles. And of course, there is the Roe v. Wade precedent that has been in power in the United States since 1973, which allows women the right to have an abortion before that fetus is viable, which is not the case in that Texas law, which, of course, as you mentioned, bans any abortions after 6 weeks, which is before most women know that they're even pregnant. But there is something in the speech by Merrick Garland that is very important. This is all very well talking about constitutionality, but the case needs to go to the court. That lawsuit needs to show some sort of what they call injury to the party that is suing, so the federal government in this case. And so Merrick Garland specified that there was also injury to federal workers who in the state of Texas would be in their jobs. Their duty would be to give the option to women to get the abortion, and they could, in the state law, be subject to those lawsuits from any American citizen who, under that Texas law, could sue anyone who, near or far, would help a woman get an abortion after 6 weeks in Texas. And that is probably the key in seeing if that lawsuit, that federal lawsuit against the state of Texas, can actually succeed.